Welcome, everyone. This is class number 25 of the July 2024 Ibis Prep Florida Bar Exam Interactive Crash Course. And this is our last substantive lecture of the entire program. And we are ending on the best note ever with Rebecca, who's going to teach us all about ethics. So Rebecca, without further ado, the floor is all yours.
Thank you, Andrew. Hi, everyone. If you remember me from Trusts a couple weeks ago, I'm back and we're going to do ethics. So I think when we hit the ethics lecture, we're at the home stage, right? We're almost done here. So I think a lot of the big bar prep also puts ethics at the end. And I think there's a reason that they do it. I think it's a pretty easy topic because it really goes with logic. Like, just think about what makes the most sense. Um, and you'll be okay. Did anyone see that, by the way? Okay. So yeah, I think if you just go with like your logic and your gut when you see an ethics question, then you can't really go wrong. And I'm gonna give you like black letter rules that we can memorize, so you're not like, I don't want to go in with just my gut, like I want to know what to write, and I'll show you what to write. Um, so we all took the MPRE. It's very similar. Of course, Florida has their little distinctions that we want to remember. But if we remember to the MPRE when we studied, a lot of it is the same material, right? We have conflicts, we have confidentiality, we have what does an attorney need to act like in front of a tribunal, communications with other parties, like we know these things, right? So we're kind of just repeating what we already know. And um, when we're looking at an ethics question on the bar, I have like little snippets at the end of my slides that kind of show us how to issue spot, but you'll see it because it'll say discuss ethical issues. So it's kind of just like teeing it up for you. And you're gonna see an ethics question, like 99%. I'm pretty sure you'll see at least one on the essays. And it's up to you whether you want to start with it or end with it. A lot of people see the ethics question and go, great, I'm going to start my ethics. I know exactly what to write. I have a good baseline of points and get into it there. Or some people want to just follow the list and do it at the end. I'm one of those people that like to start from the beginning and end. So it's really depending on how you want to do it. But I think if you see an ethics question on the essays, you're like, great, now I can, just easily type my ethics paragraphs because they're pretty easy once you get a hang of it. So yeah, let's talk about it. So Andrew has this blurb that you can say for every single ethics that you get. Um, Obviously, it's a lot to memorize, but I think that if you kind of just get the gist of it, you don't have to say it word for word. And we know this when we look at the Florida Board of Bar Examiners website and we see all the essays that they released, people are making misspellings, the grammar is all off. You don't have to write exactly perfectly on the essay to get points. So don't be like, oh, I didn't write exactly that. It's fine. If you just memorize the basic overall, Florida attorneys have certain rules that we have to live up to. And if they do not live up to those rules, are subject to discipline by the Florida bar, right? That's just basic overview, what we're starting with in ethics, right? Tee it up. And it's the same thing for every black letter law, little mini paragraph we do. Don't forget, what are we talking about? People miss points by saying, jumping right into if this is an offer without talking about, is the contract valid? Is there offer acceptance and consideration, right? People just jump to the analysis and they don't put the rule. So I think here, this is like the rule that we'll put down. If we see ethics, we'll talk about something like this, right? There's ethical considerations, and if we don't live up to it, we're subject to discipline, this, right? So try as much as you can to memorize this little blurb, but always remember, if you're starting in ethics, start with this and you'll kind of just fall organically into the rest of it. I think it's good to have some type of knowledge about, when I go in, what am I going to write? This, right? So if you look at all of the past essays, you'll see a pattern about what they ask for ethics. A lot of it is about fees. We'll talk about the fees, but if you see client is paying attorney $10,000 or something, you're talking about fees, right? There's an agreement between the client and attorney. We're talking about a fee agreement, right? So we'll talk about the basic fees, but there's also different categories of them. So that's a big topic that they test is fees, and then we'll have conflicts, right? And there's always former, current, and prospective. Um, Perspective, we'll talk about it, but people get tripped up on what that means. Perspective is a client that comes into your office. I'm thinking about getting represented by you. I'm thinking we create an attorney-client relationship, and then they say, never mind, I'm out of here. You're not actually my client, but you were a prospective client that came in. So we'll talk about, do you have duties to that person that came into your office and then left? So we'll talk about that. And then we have confidentiality, attorney-client privilege distinction. And there is a distinction. One of them is broader than the other. And spoiler alert, it's confidentiality. So we'll talk about that. And then advertising and solicitation is also the Florida essay writers love to talk about like, you know, just like wild things. So you'll see something like, oh, you know, there's a wild advertisement. Obviously, you're not supposed to do that, but there's specific advertising and soliciting rules that we can memorize and put down. So we always want to go to the rules that we remember, but if we can't remember them, just pull something that's kind of like, this seems logical, this seems right. So we'll look at those. And then professionalism and duties, these are kind of catch-alls that we can just throw in there if we see something that's along the lines of that. And don't forget, if we're kind of like, you know, some people are always worried about time, but if you have a little bit more and you're like, where can I add things to my essay? Always talk about professionalism duties, right? The attorney has to be professional, you know, has to act with truthfulness and has to respect clients. And, you know, I'll show you those. But those are kind of catch-alls that we can fill in because a lot of it will just be, you know, general, what does an attorney have to act like in blah situation? So we'll talk about those. Can't do my space bar. So basics of attorney's fees. If you get a question that talks about fees, it could be, you know, a contingency fee agreement. It could be a referral fee agreement that we'll talk about, but at its core, we're talking about fees. So we always have to start with the black letter law for fees, right? Lawyer fees must be reasonable, cannot be excessive. What does reasonable mean? It's customary in the community, compared to other experiences of other attorneys, the ability of the attorney, the reputation of the attorney, and compared with the complexity of the cases, of the case and times involved. So what does this mean? Well, if an attorney is charging $500 and every other attorney in the community charges $200 for the same work, then it's excessive, right? So we can just put this blurb in there when we see something talking about fees. Doesn't matter what type of fee agreement it is. If they're talking about fees, you got to have a paragraph talking about this, the rule, black letter law. Reasonable cannot be excessive. What is reasonable? Similar to in the community for similar types of work, compared to the experience of the attorney, the reputation of the attorney, the ability of the attorney, and complexity of the case and time involved. I'm memorizing that. I'm going to put that out if I see something talking about fees. Holding fees also is sometimes tested. So what you have to just know about a trust account, which means I have money coming in from a client. What am I going to do with it? I'm not going to put in my own bank account. I'm going to put in my trust account. That is my firm's account. And it's going to sit there by itself and I can't commingle it with my own funds. And this is super easy because we'll see a question like, attorney deposited $20,000 of the client's money into their own personal account. Like it'll just say that. And then we're like, great, now I can talk about a trust account and get 10 points, right? So what's the black letter rule? Attorneys must keep client fees in a separate trust account and they're not to commingle funds with their own personal accounts. Attorney commingled funds by depositing clients' money into their own personal account. So therefore, did not uphold the trust account rule for the Florida bar and is subject to discipline. There's my paragraph, right? So then you can sometimes get into like a business type of relationship with a client. So sometimes a client can come into your office and say, hey, I have no money, but I have a business and I can give you a share of that business if we go into work together. Or to pay your attorney fees, I instead want to give you, a piece of my property or something. So if you see something like that, where there's kind of like a business arrangement with the client, usually there's probably going to be an issue there. So I would say generally, you can't enter into a business relationship with a client because that's kind of weird, right? Like we just want to make sure that we have a fee, you pay the fee, and we can't really engage in business with our clients because it's probably not going to be ethical. But when we do that, like when something like that comes up, just say, generally, we cannot do that. However, we can accept interest in client's property for payment of fees or engage in business transactions with that client as long as, and now I have 4 elements, right? It must be reasonable. So what is reasonable? We can argue that. Fair, right? These are things that I would just put the element there and then a quick little analysis about what it is, conclude it. Don't go on to like sentences and sentences about what is reasonable, because that's not what they're trying to see. They're just put the element down and conclude it. Like that's it, right? Fair and reasonable to client, disclose to client in a way reasonably understood by client. Just put that element down. Does that have to be analyzed more? Can't speak tonight. Probably not. Client advised to seek independent counsel. It'll tell you if they did. If they didn't, say they didn't. Client did not get advice from independent counsel, so therefore they cannot enter in this business transaction with the attorney. And client gives informed consent in writing. So orally agrees that, let's do this. Did not give informed consent in writing, right? So all of these have to be present. It's an and, not an or at the end. So when I see a client and an attorney engaging in business together, I'm going to say generally they're prohibited from doing so. However, if these 4 elements are applicable, then it can be done. So that's if you're entering into a business agreement with a client, and you'll see that because it's kind of like the facts are obvious. And then there's a little Florida distinction where an attorney can put a charging lien on a homestead property. So if you have a family or constitutional law essay about homestead, and then there's an ethical issue about fees, maybe I would bring it in. Florida allows attorneys to get a charging lien on homestead property. And what does that mean? If you owe your attorney money, then that attorney can put a lien on your homestead property. Right. And so we know that there's certain creditors for homestead that can't pierce homestead. Well, we just found out that Florida attorneys can do that, can put a charging lien on your homestead property. If I didn't have a question asking something about this, I'm not going to put it down. So just know when you issue spot, I'm going to put down things that I know are being asked. I'm not going to throw random things in there that aren't applicable, because I'm not getting points for that, right? I'm getting points for big glaring issues. Like if we're talking about fees, I'm putting this rule down, right? We're not talking about homestead, I'm not going to put this down. So contingency fees are tested a lot. They may not say attorney and client enter into a contingency fee agreement. They're not going to say that 100% of the time. So how do we know that we're talking about contingency fees? There is going to be some wording that attorney gets a certain percentage of the client's winnings at the end of the trial, right? That's a contingency fee agreement. Typically, the attorney doesn't get any money until the end of the case. And if the client wins, then the attorney gets a cut of that, gets a percentage. If the client loses, then the attorney doesn't get anything, right? That's a contingency fee agreement. So what's the rule? Contingency fee agreements are allowed, but there are certain qualifications to make a valid contingency fee agreement. And the first rule is that you can't have it in a criminal or family case, a domestic case. So if you see enter to a contingency agreement with my client that's on trial for murder, can't do that. What do I say? Contingency fee agreements are generally available. However, they're not available in criminal cases. Therefore, this is an invalid fee agreement and unethical, right? It's like, close it. Divorce and child cases are called family and domestic cases, right? So if I see anything like that, child support, alimony, Divorce, I can't have a contingency fee agreement. I would just say it, right? Cannot be in a domestic case and then move on if I see something like that. So if I do have a valid contingency fee agreement and it's not in those groups of cases that I can't have one, then it has to be valid. And for it to be valid, it has to be in a writing and signed by the client. So has to be in writing. Like you got to say that. If you're talking about contingency fees, put it in a writing, signed by the client. Show how the fee is calculated. So in the fee agreement, it says attorney will get 30% of winnings, right? It will say how much they're going to get at the end. So there's a rule in Florida that it's typically 15 to 40% is a contingency fee agreement. That's okay. Like that's an okay percentage. Anything over is presumed excessive. So if we have a presumption, we can rebut it. So what am I going to do here if I see something that's like really asking me about this? They're talking about a contingency fee agreement. They're talking about percentages. I'm going to have to talk about this, right? Let's say the contingency fee agreement was 41%, right? I would say typically 15 to 40% is an okay fee agreement. That's valid. Anything over is presumed excessive. However, the client will argue, blah, blah, blah. The attorney will argue it's not excessive because of blah, 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 right? There's a presumption, but it can be rebutted. You know, maybe you can put an analysis in there like that. So in writing, show how calculated, and then show other expenses that are possibly deducted, right? If you have a filing fee with the court, you know, any other type of expense that the client has to pay, and then show if that is deducted before or after that fee calculation. So that's just another little math thing that they want in the contingency fee agreement. So in writing, show how it's calculated, and then show any other expenses that are deducted, and if it's before or after that calculation. Just commit that to memory if you're thinking about writing a full contingency agreement paragraph, because these are pretty easy points if you remember, and they love to test in contingency. Like I've seen so many contingency fees. Then you have a statement of client's rights. That's a like piece of paper that they give for personal injury or property damage cases, and that's just kind of like an overall contingency fee. I'm giving you your rights as a client, and this goes over, you know, what our agreement is between the client and attorney. These are your rights in it. Like it's just a piece of paper that is a typical it's SCR, like I would abbreviate it, in personal injury or property. And then just know that if that's given, then the client has 3 days to retract and not be represented. So, you know, you give it to the client, they look at it and say, I don't agree. You have 3 days to retract it. So just know if you have a contingency fee agreement in either personal injury or property damage, then usually a statement of client's rights is given. And then if it is given, then the client can review and then have 3 days to retract if they don't agree with the representation. That's going to pop up again in a later slide, but just know that that exists. Again, we have MPRE type of things, but there's little Florida distinctions, right? So we know what a contingency fee is, just know in Florida, there are certain elements that have to be met. Any questions? I can't see the chat, but I'm going to just keep going. Please yell out because I can't see the chat. So referral fees. So if we're getting a question about fees, we're probably going to get a question about contingency fees, and we may get a question about referral fees. So if we get a referral fee, how do we know if we're talking about one? An attorney refers work to another attorney and says, I'm going to get a percentage of the client's payment, right? So I'm going to give you, like I do family and you do, also there's no like family or criminal distinction here. That's only for contingency. So just put that on one side. This is a referral fee. So let's say there's, you know, a family attorney and a personal injury attorney that are friends, and the family attorney says, hey, I have a friend that just slip and fall, you know, take my friend for work and, you know, give me 10%. Can't do that. So you can definitely, like if it was a family and a family attorney, you can work together and be like, you know, what's this new statute? Let's talk about it. But if I'm referring work out and I'm not doing anything because I'm a family attorney, I'm not doing a personal injury matter. If I'm referring work out and I'm trying to get a fee of that work, then that's unethical. I can't do that. So just look out for something where there's a referral going out and the referring attorney does none of the work. If that's the case, then that's unethical, and that's what I'm going to write, right? Black letter law, referral fees are unethical if the referring attorney does not do any of the work and there's only one attorney that is assisting the client while the other attorney reaps benefits, payment. That's unethical. You can have ethical referral fees as long as they're in writing, right? We always have a writing. And then shows that the amount of work divided between the two attorneys that are the referring attorney and referral attorney are proportional to the amount of work done. So one attorney gets 20% of the fees because they did 20% of the work, and the other attorney gets 80% of the fees because they did 80% of the work. So it shows the referral fee agreement will show that it's proportional, right? Or it will show that the attorneys are jointly liable for that representation. So if one of them does something wrong and the other one didn't, too bad, you're both jointly liable, right? So it's an or here. You can either have a proportional, divided by percentage of the work allocated agreement, or the agreement can say, we're gonna do this referral fee, it's in writing, and we're gonna be jointly liable on it. So just know that that exists. So if I'm getting a referral fee thing, I'm going to put the black letter law and I'm going to say, it's not valid or it is valid because it doesn't or does hit these elements, right? So I'm always going to talk about the elements. Even if I see the referral fee in the question, I say, there's no way this is a valid referral fee, right? This was an oral one, or, it doesn't have proportional percentages of work. Even if I see that in the essay, I'm going to still talk about the elements. Even if I know my conclusion is this is an invalid fee, referral fee agreement, I'm still going to put the black letter law down because why not? I'm talking about something. If I see the word referral or I know I'm talking about referral fees, why am I not putting down the black letter law? I'm missing points. So don't get caught up of like, I know the answer is no, though. Doesn't matter. Put it down there and then get to the no. Even if you're wrong, you still get the points for the black letter law, right? Also, you can't have a referral fee agreement, even if it's a valid in writing and proportional and whatever. You can't have that if it's with a non-attorney. So engineers and attorneys can't get together and be like, let's create, a PLLC with attorneys and engineers working together. You can't do that. You can only have this agreement with other attorneys. So if you get work referred by an accountant or you get work referred by, another professional, financial advisor, you can't do that because that's not an attorney. And we know that also when we study for the MPRE, if anyone remembers, you can't enter into like a joint business venture with a non-attorney if you're rendering legal services, right? We know that. So just know that, if I see a question where an attorney and an accountant are, trying to refer, I'm going to still talk about what a valid referral fee is, even though I know that it's invalid because it's between an accountant and an attorney, right? If I have a third party paying my fees, so what does this look like? Mom comes into office and says, my son is a minor, and got hit by a car and I want you to represent him and I'm going to pay his fees. So that happens all the time, right? But just know that if we do have a third party paying fees for someone else, the actual client, so the son, would have to give informed consent. And, maybe if he's a minor, there's, some other statutory reason why something else comes into play, but just know that the actual represented client, not the third party paying the fees, the client has to give informed consent, and the attorney has to make the decision that the third party paying the fees is not going to interfere with their independent advocacy of the client. So if the mom is like whispering in the attorney's ear, you got to do this, you got to do this, like, don't forget, I'm paying your fees. You can make the argument, okay, well, the attorney is not going to have independent advocacy for this client because the third party is getting way too involved. And then also information between the client and the attorney is privileged. So attorney can't tell the mom, this is what I talked to with your son, right? So it's a weird situation here, but if I saw a third party paying fees, I'm going to say, generally that's okay as long as these are met, right? The client has to give consent, can't interfere with independent advocacy, and there's still attorney client confidentiality, right? And privilege. So just, even if I know the answer is no, I'm going to talk about all the elements. So then we also have like a little Florida distinction with insurance cases. So if you get into a car accident, sometimes your insurance company pays your fees if you get, into a lawsuit with that. So what are they? We see this again, the statement of client's rights. So what is this? This is typically in a contingency fee agreement, right? Where they give a statement of client's rights, and what does it say? It says, well, the attorney must follow the instructions of the insurance company. Attorney may share confidential information with the insurance company, and the insurance company has a decision to settle or not, right? So it's a weird situation where the insurance company is kind of making some decisions here, even though they're not the client. But it's kind of like that one-off rule that allows us to give a little bit of flexibility with these rules just because it's the insurance company. Just know that the settlement thing is only for the client to decide if we're not in this insurance realm. So if you have a question that's asking, the attorney gets a settlement offer for $10,000 and they know, like, yeah, my client's never going to accept that. Like, I'm rejecting. That's unethical. You have to go to your client and say, you have a settlement offer for $10,000. Do you want to take it? You have to let your client make that settlement decision themselves. That's totally unethical. You can't make a unilateral settlement decision with your client. So that may pop up. Just know that usually an insurance company, in cases with the statement of client rights, the insurance company can make that decision to settle, right? So usually that's the client's sole discretion, but in this case, the insurance company can. So keep that in mind. Court, this is, I think, the last fee slide, so bear with me. I know, super fun topic, but court may award fees in certain ways. So there's a Florida statute allowing attorney fees to be paid to the prevailing party if the non-prevailing party acted in bad faith, right? So if they did something, erroneous or whatever, or they didn't follow the rules or whatever, then the winner of that lawsuit can say, hey, loser, you have to pay my attorney's fees because I litigated this matter and you acted in bad faith, and now you have to pay my attorney's fees. And Florida has a statute allowing that. So when you see court awarded fees, the tribunal, the court is awarding fees to the attorney. So it's not the client paying the attorney, it's the court paying the attorney, right? So I can either have it by statute, I can have it by contract, where I enter into a contract with you and say, if we ever go to a lawsuit, then, X pays attorney fees. I can stipulate that in contract, right? So that's the second way, or then you can have a sanction. And so if you're sanctioned, usually the sanctioned party would maybe have to pay attorney fees to the non-sanctioned party. And then we'll see that a lot if there's like a frivolous argument brought, and I have a frivolous, like what is a frivolous argument on another slide. But just know that if an attorney is sanctioned, and you can have different types of sanctions, right? We know that from Civ Pro, but just know that one option for sanctions is that now that party has to pay attorney's fees for someone else. So how do we see this? We see a question that says, the court is awarding fees to the attorney, and, is this proper? And you can say, yes, a court can award fees for an attorney if these three things are applicable. And because it happened, then yes, this is a valid court awarded fee. Just go through the elements and get to a conclusion and just like put it to rest, right? We just want to issue spot. And when we see it, we go, oh my God, that was in my outline. That was on my slide. I know what to write. Let me write it. Let me just put my analysis down. Let me conclude it and let me move on. I'm not going to sit there and start arguing, right? The advocating comes once we become attorneys, right? I'm going to say my black letter law. I'm going to do my analysis. I'm going to probably argue both sides if that's what the prompt tells me to do. And then I'm going to conclude it. I'm not going to fight the black letter law. I feel like people in like ethics, especially, like, I have to do what I think is right. Some of the ethics things are like, ugh, but that doesn't make any sense. Don't fight the black letter law. Whatever it says, just be like, okay, whatever it says, memorize it, put it on the paper. Don't even think twice about it. You can start advocating once you become an attorney, but at this point, just take it as it is. Don't fight it, especially with the conflicts that come, but we'll get there. And we're there. So conflicts of interest, right? So there's three main topics of conflicts of interest. And it's when you have a current client, when you have a former client, so that's someone that you represented in the past, and now their representation is over, and now they're considered a former client, or a prospective client, right? And I talked a little bit about that when someone comes into your office, talks to you maybe about forming a attorney-client relationship, and then maybe changes their mind and then walks away. So I never became your attorney, but you disclosed to me information, right? And we'll talk about, what happens when that is disclosed to me. Like, what are my duties as an attorney for that prospective client that came in? So I took this from the Florida statutes, right, for ethics. And at my last slide, I have where I pulled them. So if you want to just like review them and just read the statute, like I said this in my trust outline, but my trust lecture, but I really like reading the statute, which is kind of like, oh, I don't want to read the statute, but sometimes you're just like, I don't really understand that. Let me just read what they wrote, like what I'm being tested on, and just compare that with my notes and make sure that it's correct, because there's ors and there's ands and whatever, and we want to make sure that we know what it is. So I have that in my last slide that if at your leisure you can review. So we have a current client rule. So an attorney cannot represent a client that has interests directly adverse to another client that they currently have, or that attorney's independent judgment is materially limited by responsibilities to the other client. What is materially limited? That's the part that you're going to have to argue, and you're going to have to put an analysis and say whether or not you think it's materially limited. But I can tell you right now, you'll probably get something about a divorce, or you'll probably get something where there's on the same side of the transaction, right? Or I'm giving a property to someone else, the seller and the buyer. Am I representing both of those? Like, can I represent both of those clients? Well, their interests are directly adverse, right? So maybe I can't, because one's the selling and one's the buying. How do I represent both of them? Because their interests are adverse. Technically, they're on different sides of the transaction. Or if one party is suing another party and they both come and they want me to represent them, how do I do that? So I can't if they're directly adverse, right? Or I can't if I believe my independent judgment is materially limited. So how do I argue this? And when I see a question that's asking me this, I'm going to talk about, well, an attorney can't represent a client whose interests are directly adverse from one another. Here, the client's interests are directly adverse because one is the divorcee and one is the divorcee, however you pronounce that, in this family matter. Therefore, they have adverse interests, so it would be unethical for the attorney to represent them because they cannot diligently represent them and exercise independent judgment, right? Or, right, so there's that part, or the attorney's independent judgment will be materially limited by their responsibilities. So I can have two clients who are directly adverse and say, maybe I can represent them, but if my independent judgment is materially limited from that, and usually it is, right? If they're adverse, directly adverse, usually it's my independent judgment is materially limited, right? So that's kind of an easy analysis. To my responsibilities for my current client, I can't do that because I have a current client right now that I, have responsibilities to. So I can't represent both of you. So either or of these, one or two exists, right? That's directly adverse or materially limited. However, I can still represent them if I do believe ethically that I can represent them, right? So there's always the lawyer. I know, like, you'll probably learn this more in practice, but the lawyer can always turn down representation if they truly believe they unethically cannot do it, unless the court like forces them, but that's kind of in the weeds. But a client comes to your office and says, I want you to do this thing. And you're like, I just can't ethically do this, right? There's just something that's there. I can just not represent you. I can turn down clients, right? You're not forced to represent someone that walks into your office. You can turn down the representation. My firm does that all the time if we don't want to take something on. So I can represent two clients directly adverse, and my independent judgment may not be materially limited. However, if I reasonably believe that I can represent them ethically and my judgment will not be affected, and the clients give informed consent in writing, both of them, informed consent in writing, then I can represent them. So if I have the buyer and the seller of a transaction of a real estate property, right? If I'm like, they're directly averse, I can't really represent them, but they say, listen, it's a shorthand sale, you know, he's my dad. I just want you to draw up the contract. There's nothing wrong here. Like, he's in agreement, I'm in agreement. We know the consideration amount. Then that attorney can say, hey, like, I probably can ethically represent them both. My independent judgment won't be materially limited, and the two clients will give informed consent in writing. Then I can represent them, right? So this is kind of like a push and pull situation where if I saw this on the bar exam, I'm going to talk about that rule. I'm going to say attorney cannot represent a client if one or two, unless I can reasonably believe I can ethically represent them and they give informed consent in writing. I'm going to talk about that black letter rule, and then I'm going to get into like, maybe I can't, maybe I can, right? And talk about the facts. And that just comes with practice, right? Issue spotting and just creating facts of what you think is wrong or right here. That's why like the logic thing helps in ethics. So that's current clients. Former clients or clients that, you know, I represented in the past, and now I have a new client coming into my office and saying, hey, I want you to represent me. And then I go, wait, I just did a conflicts check and I represented a client 3 years ago that was in a same or substantially related matter to you, right? So that same or substantially related matter from the client that's in my office to the client I represented 3 years ago that I no longer represent, but is my former client, that matter, you guys are materially adverse to each other. Either they're materially adverse, which means, you know, maybe they sued each other in the past and now they're trying to sue each other again, but now I'm helping the wrong guy, right? Like maybe something like that. Or I'm using that information that I had on that former client to the disadvantage of that former client when that new client comes in, if that makes any sense. So either they're related in the same and substantially related matter with each other and they're materially adverse, or I'm using that former client gave me information that now I can use with this new client, but maybe it's at the disadvantage of that former client. So maybe that former client was, you know, a director of like a waste management system, and I know that they have a certain chemical or whatever that they use. And then I have like a IPA guy come in and wants to be like, hey, I'm environmentally conscious and I want to try and sue this guy. And he was my client 3 years ago, and I know that he has this chemical. I can't use that information at the disadvantage of that former client with this client that just came into my office, right? Is that like a better way to think about that? So I can't represent them both unless the former client gives informed consent. The rule does not say in writing here. You can fact check me on the website at the end of the slide, but it does not say in writing. Just accept it. Former client gives informed consent. What is informed consent? Well, that they really know what's going on and they're told, you know, in a way that they can reasonably understand. I wouldn't get too much into it. Just know the former client gives informed consent. Then you can represent that guy that comes into your office, right? The new guy. Then I can represent you. If the former client, if the, you know, the waste management guy gives me informed consent, then I can represent the IPA guy. But I can't use that information about the chemical to this disadvantage still. I still can't use that to the disadvantage unless it's generally known. What's generally known? They published an article that this guy has this chemical. Then that's generally known, and then I don't have to worry about keeping that confidential because it was published in an article, right? Just I'm talking about MPRE things that I remember from, you know, however long ago when I took it. Feels like 10 years, but that's the former client rule, right? So think about, you know, did I find out information that I could use at the disadvantage of my former client? Or is this client that's coming to my office in a same or substantially related matter with my former client with, you know, materially adverse interests, right? Can I do that? So I'm going to talk about black letter law, and then I'm going to do an analysis. Can I represent them? Can I represent them? Well, one would argue this. One argue this, err on the caution of like perfect attorney. And I know like people say that when you're doing like an ethics paragraph, always be like the really super reasonable guy, like, no, I should probably turn this down, right? Like just try and err on the side of caution. Just don't put on your like attorney hats, right? You know, put it on for the right purpose, but don't be like, I'm gonna argue both ways. Like just be like, you know, reasonable person. So That's for a former client. So current, former, prospective clients, right? They're not technically my clients. They came in to inquire, but then they walked away. So if they told me something, right? So let's say they told me, listen, I want to sue my ex-husband or whatever, and I know that he stole $10,000. The wife comes in and tells me that, ex-wife, and then she decides she doesn't want me to represent her and goes away. So I still have a confidentiality for what she told me. So I can't tell, someone else that that $10,000 was stolen because she told me that in this almost representation between us. She came in inquiring with an attorney-client relationship in her mind, and she told me that in confidence. So I can't use that to her detriment or to his detriment or whoever's. I can't divulge that information at all, right? So first, I can't do that. If someone comes in and tells me things about someone else and it's, adverse to that person, I have to keep that confidential, right? Also, I can't represent a client with interests that are materially adverse to that prospective client. Same as former client rule right here. Same and substantially similar matter if I received information to use at the disadvantage of that prospective client, right? So I have a prospective client come in and say, I know my husband stole $10,000, and then she walks away. And then I have another client come in and say, hey, like I'm trying to, defend this guy who's the ex-husband from, a fraudulent $10,000 charge that he didn't do. Well, I can't represent you because I just had a prospective client come in and I have adverse interests here, right? That's a same or substantially similar matter. And I found information that can be used to the disadvantage of that prospective client, right? So I know information here, I can't represent you. So that's the prospective client rule. Don't forget, even if people inquire and then walk away, I still have duties to them, right? So that's like the black letter law that I'm going to talk about, that I still have the duty of confidentiality to prospective clients, and I can't represent clients that have materially adverse interests to the prospective client if it's in a same or substantially similar matter. Those are just words that I want to memorize, and that's my black letter rule that I'm going to throw down. And sometimes we're not even paying attention to what we're writing, right? I'm just going to like blah, 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 type what I remember, even if I can't even like think as fast as I'm typing. And like, that's the goal, right? We want to type as fast as we can that like our brains can't even catch up. If I see something about prospective client, I know my rule, like I'm putting that down, right? So I can't do that, right? Also, if I can't do that and I'm an attorney in 50 attorney law firm, my inability to represent that client is imputed to other attorneys at my firm. So if I learn that disqualifying information, if I learn that there's a $10,000 embezzlement or whatever, then all the other attorneys in my firm also can't represent that prospective client. They can't do it because it's imputed. So if I have an imputation, that means that the rest of my firm is barred from representation as well, except if the former and prospective client gives informed consent in writing. Okay. Former and prospective client gives informed consent in writing saying, I know that I told you this information, but it's okay. We have interests that are materially adverse from one another in a same or substantially similar matter, but that's okay. Like we agree. So that could happen. And then the imputation is okay, right? And then we can represent you for sure. If the former and prospective client gives informed consent in writing, or the attorney who learned of that information, so me, I just learned this, I have to take reasonable measures to stop exposing myself to this disqualifying information. To the extent that to determine if representation of the prospective client is possible. So if I get this information and I'm only asking questions to the extent that I can represent you, I'm not really inquiring too much like, tell me more, tell me more. I'm not doing that. I'm giving myself, reasonable measures to avoid more exposure. Argue this, right? Who knows what this means? Just argue it one way or the other. And then that disqualifying attorney, so me, I'm screened from the representation. I say, listen, I just learned this. I tried not to expose myself to too much, but I'm going to screen myself from the representation. So I'm not involved. I'm not getting any fees from it. I'm not putting any time in. if I'm screened and I'm taking myself out of the situation, if I'm screened and then written notice is given to the prospective client. So compare this with informed consent. That's not what I'm talking about here. I'm talking about just written notice. All you got to do is just give the prospective client written notice and say, hey, you know, the information was received by this attorney, but that attorney is screening themselves and we can represent you, just giving you written notice, right? If those two things happen, then even if the imputation is here, that's fine. We can still represent this prospective client. Okay, so if I have a prospective client coming in, that's when this imputation rule kicks in, right? So just think of imputation as like a subset of prospective client. Hopefully this slide kind of makes it make sense. But again, I would really recommend like going to the statute and just reading what they have. And not getting too caught up in the weeds. Like if I see two clients coming in, blah, 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 I'm just going to say, hey, am I in a current client situation? Am I in a former client situation? Or am I in a prospective client situation, right? I'm going to look at my buckets and be like, where am I? And then I'm going to remember my black letter law for each. And then I'm going to do a great analysis. And then I'm going to conclude and move on with my life. So conflicts. Confidentiality, attorney-client privilege. Confidentiality is very broad. So when a client and attorney are talking during representation, it literally can just be like, I hate my wife, right? It can just be like something that it's related, like let's say we're in a divorce and it's related to the representation, like, oh, I hate my wife. That's like, that was said to me in like, this is a confidentiality discussion we're having. So I can't tell anyone that. Even after death, even after my client dies, I can't disclose that information that he told me in confidence during this representation. So I can't say that unless I believe that my client isn't going to engage in criminal behavior. And what is criminal behavior? Fraud, right? I'm about to embezzle money. I'm about to wire funds across seas. Like I'm about to like economically damage someone, right? So will engage in criminal behavior or will cause bodily injury or death. Compare that to already committed a crime. I'm thinking about killing my wife and I'm taking reasonable steps to do so. I have to go tell the police. Compare that with a client that comes in and says, I just killed my wife. If someone says that to me, I'll be like, oh my God, don't forget, I can say, I ethically can't represent you just because of my own values, right? You can say that unless you're court appointed. But if that happened, that's confidential. I can't tell anyone that you told me that you killed your wife because you already did it. It's in the past. That's a crime in the past. I have to disclose information if it's crimes that will happen in the future. You're telling me you're going to do it. Then I have to disclose. Or the client gives consent waiving confidentiality. Comes up again, the SCR, right? So in that case, the attorney has to talk to the insurance company about certain things that are considered confidential, but the client waives that in the agreement, right? So the client is saying, I know you have to talk to the insurance company about that. That's fine. So client can consent, client can waive the confidentiality, or the disclosure is implied by authorization. So if I have to call medical records or something and say, you know, my client has this disease and I have to talk to you about it, I'm technically giving them, you know, confidential information, but I have to do that to represent my client. So it's kind of authorized, like impliedly, I have to talk about these things to be able to represent you. And then there's also like the no more than necessary rule where, you know, I can do that to the extent that I don't disclose information more than necessary that I have to. And that's just, again, an argument that you can make. So that's the duty of confidentiality. Think of that as like a huge circle. And then inside that circle is attorney-client privilege. So attorney-client privilege is like an evidentiary rule. And that's like, you know, attorney gets on the stand and then the client can claim the privilege and say, I'm not going to talk about what tell me what you talked about in your relationship, in your meeting with your attorney. The client's going to be like, no, because this is privileged and I'm claiming my privilege and I'm not talking about what I talked about. So the client can claim that, or the attorney can claim that on behalf of the client. And the attorney gets on the stand and says, well, on behalf of my client, you know, however that works out. But you can't force an attorney or a client to disclose information about what did you talk about. And so it has to be related to the legal services. So it has to be in the rendition of legal services, not intended to be disclosed to a third party. So it only has to apply to communications made in actual rendition. So what is this? It's like work product. It's like legal strategy. It's like, you know, think of it in like a trial sense where it's more narrow in scope and it's kind of like, okay, well, you told me this while we're preparing for trial. Like this is something that helps me in my strategy, helps me as an attorney. That's not like an opinion that you just gave me. That would be like duty of confidentiality type thing, right? So that's like a really broad scope of like pretty much anything that you tell me relating to this representation, I can't disclose. But in the attorney-client privilege, it really has to be intended not to be disclosed to the third party. And then if that intent is there, then it's privileged, right? So I'm telling you this like legal strategy that I did that I'm trying to help us in trial, and I'm not intending to disclose this to a third party because that hurts my case. So that's not intended to be disclosed. Compare that with duty of confidentiality, where I'm just telling you things and like, you know, we're talking about the representation, but I'm not intending it not to be disclosed. Like maybe I'm just talking to you about anything, like you're my friend or something, right? So again, both of these don't apply if it's communications in furtherance of a crime, right? So tell me about when you were talking to your client, you said that you wanted to kill your wife. Then that maybe is not privileged because now it's in furtherance of a crime. Also, small caveat, you can't do this. You can't claim a privilege or you can't invoke confidentiality if you're in like a legal malpractice, right? So if a client sues me and says, you committed malpractice and you didn't represent me ethically, then I'm gonna be able to break these duties because I'm gonna say, well, I have to talk about what we talked about because then I have to defend myself in this malpractice action, right? So, you know, if that comes up, right, the client sues you for malpractice, is the duty of confidentiality waived? Like, you know, talk about the rule, right? Attorneys must maintain confidentiality and not disclose information related to representation. However, if a client sues for for legal malpractice, then the rules of duty of confidentiality will not apply because the attorney must be able to defend themselves in the suit, right? So think of like huge bubble is duty of confidentiality, little bubble inside is attorney-client privilege, which is like an evidentiary rule. If I saw my question about the attorney getting on the stand or something, or they're in a deposition or something, then I'm gonna think about attorney-client privilege. But if I just see like, you know, my attorney talking to people on the street about my case, then I'm talking about duty of confidentiality, right? I'm gonna say my little duty of confidentiality blurb with my rule and analysis and conclusion, and then move on. So two distinct things.
Rebecca, I had a
Yes,
question. I'm sorry, I didn't know if you could see the chat. I had a question
yes,
about prospective clients.
sure.
There was just an if on your slide, and I kind of wanted to clarify. It said, where was it? I'm trying to think because the slide moved on, and so I wasn't sure. But
I
if
just changed it. Do you see it now?
yes, so it says if attorney received information that can be used to the disadvantage. So let's say you meet with a prospective client and it's a pretty public case, so all the details are kind of out there. And then
Mm-hmm.
they're like waiting to see if they actually want you to be their attorney, and a client directly adverse to them comes in and does the same thing. Do you then, I'm assuming you still have to then update that first prospective client, like, hey, I'm representing the side or
Yeah.
whatnot, even if you didn't learn any information, or how does that, I guess,
Yeah,
work?
so it does like I did take this right from the statute. So it does say if. So I would read this as yes, I can't represent two clients with materially adverse interests and same or substantially the same matter if I received information to use at the disadvantage. So if I did represent them and they are materially adverse in a same or substantially matter, but I didn't receive any disqualifying information to the disadvantage, then perhaps I can represent them, right? So I would definitely talk about the black letter rule. And then if the question on the essay talks about something like that, then I would bring it up. But I think that we're already in the weeds. I don't think that the ethics question is going to be like super specific like that, where can I represent on this one little if? I would definitely talk because I think the extent of what they'll say is prospective client comes into your office, and they were in a lawsuit with your former client 3 years ago, and now they want to sue them again. Like that would be the extent of what it is, and then I would just do black letter law. Definitely I could check on that rule for you and just like copy and paste it and see like it says if. So at the end of my thing, I have like the case text or whatever that I got from like Thomson Reuters, and like we can take a look. But yes, the language of the rules are like super confusing and there's ifs, ands, and buts. But just know there's like certain black letter rule that we're gonna memorize. And I don't think the question is gonna throw too many things out there where it's like super distinct like that, where I'm doing a whole ethics analysis right here. You know what I mean? The bar exam is not gonna give me a whole ethics essay. I mean, maybe I just don't think they will. Andrew can maybe stop me on this, but I think they're gonna give you a topic and then they're gonna give a little ethics blurb at the end, talk about this, like, you know, and then it's gonna just be pretty easy about what they're gonna ask about. I don't think it's gonna be a super like distinct thing like this. If that is helpful.
Yes, thank you.
Great. So this is the fun one, advertising. It's just basically attorney cannot have false or misleading advertising. That's easy. What does that mean? Well, I can't say I won all my cases and I've tried one case, right? So that's like the pretty easy one that they give options or examples about. So I also can't like guarantee like 100% success rate. Like I promise that you'll win your case or something like, you know, we're the best attorneys in the world voted on like lawyers.com or something like something crazy and like outlandish. I can't do that on my advertising. So just know attorney cannot have false or misleading advertising. I can't talk about areas of law that I don't practice. I can't say like, I promise I win all your cases no matter what they are. Like, you know, I may be a PI attorney and I can't promise that I'm going to win your family law case, right? So that's just like little things about false or misleading advertising. And then Florida has this really weird thing where you can advertise via mail, but you have to say that it's an advertisement in red ink on the first page of mailing and the lower left part of the envelope. Yes, I pulled this from the rule. So you don't have to be like, oh my God, I'm not going to remember it's lower left and not lower right. Who cares? Just say that attorneys cannot have false or misleading advertising when they do advertise to prospective clients. There's certain requirements, right? It can't be misleading or deceptive. I can't guarantee any outcomes. I can't reference law that I don't practice. I have to say where I am and who I am, right? The attorney and firm location must be provided. And I can advertise via mail as long as I disclose that it's set, that this is an advertisement in red ink, or even if you don't say red ink, you know, if you don't remember. But I must disclose that it is an advertisement. So that's all that really means, is just saying this is an advertisement, right? So that's the advertising rule. It's kind of just like, we get it. And then we have soliciting, where an attorney can't solicit business, like going out, like, I'll represent you, like everyone come to me. And like, you know, I'm going to all these people and I'm trying to ask questions. You know, what's wrong with you? Like, you know, do you have an injury or something? If I'm, you know, usually this happens with like ambulance chasers, right? I can't find this car accident and then chase the ambulance to the hospital and be like, I'll represent you. So I can't solicit business unless I have a family or prior professional relationship with them. So if my mom is complaining to me all the time, like, oh my God, like I just got fired from my job and I think it's bad. And I'll say, you know, I'll represent you, mom, right? Like, you know, quit your job and then I'll represent you as, you know, wrongful firing or something. You know, I'm just making stuff up at this point, but she's my mom. I can solicit her technically. I can say, I'll represent you, like, you know, I'll help you here. I can go out of my way and try and get your representation because you're my family member, or if I have a prior professional relationship with you. So if you're my accountant for many years and I know you and we have a professional relationship and I know you have this issue going on, I can solicit to you and say, hey, I'm this, you know, I'm an estate planner and I can do your estate because you have problems with your wife, like, you know, come to me. So I can do that because I have a professional relationship with them. So I can't solicit to people that are not my family members and I don't have a prior professional relationship with them if my motive is pecuniary gain. So if my motive is money, and 9 times out of 10, the motive is money, right? I'm not trying to be a good person and giving free legal advice on the street, unless you are, but usually it's for money, right? So that's just the black letter rule, right? Attorneys can't solicit if there's no family or prior professional relationship, if the primary motive is monetary gain. That's my black letter law. Here, the attorney followed the prospective client around the block, yelling, please let me represent you. This is obviously soliciting and it's invalid and unethical. So therefore, the attorney will be subject to discipline. Right? just don't fight the facts. They'll probably give you something kind of similar to that, right? It'll be obvious. Usually in the ethics things, they're kind of just pointing you to something that's really bad, and you're just going to have to organically follow them, right? Don't fight them on it. Like, maybe it's right. Just take it as it is, right? So then also like the ambulance chaser type of thing, I can't contact that injured victim unless 30 days have passed. So this person is in a hospital and he's sick and I have to wait 30 days before I don't know, send him a mail, right? Send him advertising like, hey, do you need a PI attorney? So I can't contact unless 30 days have passed, right? And that's just like, Florida rule, that if there is an injured person, then, and they're a victim or something, right? So maybe it's like a domestic matter and they're a victim. I can't contact that person, that victim, unless 30 days have passed. And that kind of gives them like a little bit of like a buffer zone to understand what they want and what type of representation. It's just like this ethical rule that they have, 30 days. I'm praying for an advertising and soliciting question, honestly, because that's kind of straightforward. And then you'll get something wild, like the advertisement is like, like, let me hire you and you'll win the jackpot or something. Like they'll probably do something that's like so outlandish that you're like, this is definitely false and misleading, right? And you can easily argue a great analysis and then conclusion, and then you just got yourself a lot of good points. So, these are kind of catch-alls, right? So if I have an ethics question and the attorney is doing some bad things, maybe they're representing two clients that are materially adverse with one another. Maybe, they're putting money into their own personal account and not a trust account. If I'm seeing anything that the attorney is doing wrong, and the attorney will be doing things wrong. If you have an ethics question, the attorney is doing things wrong. That's how you try and get this like ethics mind moving. So if I get something like that, these are things I'm going to throw in and say, hey, the attorney is unethical because they commingled funds, but also, there's always a duty of competency. So this attorney was not, living up to the standard of competency because they did not, as a professional, learn the skills or preparation for this case, right? So if there's a attorney that's right out of law school and then is given a, murder trial for this guy, and he did nothing to prepare or didn't like seek help from another attorney, then this attorney is not competent to try this case, right? So if the attorney is not competent, the lawyer must turn down representation and say, I'm not competent to represent you. I don't have the basic skills, preparation, and knowledge to represent you. So I'm going to talk about competency if I see a lawyer doing things wrong. And those are easy points, right? So don't forget, I have my starting off sentence about there are rules for attorneys to follow for the Florida bar ethically. And if we don't follow those rules, we're subject to discipline, right? That whole blurb that we're trying to memorize as much as we can though, then there'll be a rule that I can see from issue spotting. And then I'm going to throw in my professionalism catch-alls. So I'm going to talk about duty of competency. I'm going to talk about duty of loyalty. Attorney must maintain duty of loyalty to the client, no self-dealing. We kind of know this from business entities, right? So the client is like in confidence talking to you like, my stock options are not doing too well, but I heard that this good stock is going to come up, but it's going to really hurt me if it's bought. I'm making stuff up. And then the attorney is like, oh my God, I'm definitely going to go buy that stock option, even though I know it's going to hurt him. Then you're not loyal to your client, right? The guy's talking to you and he thinks that you're his attorney and you're representing him in his best interests, and you just self-dealed. You bought the stock you know is going to hurt you, or, you did a shorthand sale, something that is like against the duty of loyalty, and use the same framework as the business entities thing, because that's kind of like a similar thing, right? We are fiduciaries to our client. We have a fiduciary duty in some respect. So there's competency, loyalty. truthfulness, which is a weird one, but it's true, right? I can't knowingly make a false statement or material fact to any third person. To any third person, especially my client. I can't lie to my client. But as an attorney, we're subject to this rule for third parties. So if I have the court clerk on the phone that says, did you file this? And I know I didn't. And I said, yeah, I definitely filed that. I'm making a false statement of material fact to that third person. As an attorney, I'm subject to discipline for doing that. And that's like a serious rule, right? Once we become attorneys, we're held to the standard where I can't lie. I can't materially falsify facts to people and get away with it, right? Like we're held to the standard of professionalism. So duty of truthfulness, if I see things that are, being untruthful, I'm going to talk about this. And then we have candor of tribunal. So I have to be truthful, just like to third parties, to the tribunal, to the court. So when I submit claims or I submit defenses in court, I have to make sure that they're not frivolous. And what is a frivolous claim? It's one with no basis of fact in law, and it's not submitted in good faith to extend, modify, or reverse existing law. Just to make sense of what we're talking about, attorneys can argue and say, I think this law should be changed because of a serious reason, right? I'm doing due diligence and I'm doing legal research and I'm getting case law and I'm really putting down a claim that I think has a good argument backing it. Comparing it with, I'm just going to throw something at the wall and hope it sticks. And, I didn't fact check my work. I have no idea what's going on. That's a frivolous claim, right? So if my client comes in and says, like, this is just totally trust me on this, like it's blah, blah, blah. And I just believe my client and didn't submit a claim and it's false, that's on me. That's not on my client. So I can't submit frivolous claims to the court. And compare that with like a good faith argument, right? And we can always argue one way or the other. And then if an attorney knows that their client is going to like falsely testify in the stand or something, then I have to take reasonable steps to stop that from happening. So if my client comes up to me and says, I'm going to lie on the stand tomorrow, I'm going to have to call the court probably and say, listen, I think my client is going to lie on the stand tomorrow. I'm just letting you know. So that is kind of like a weird little ethical, caveat here. Like, we have a duty of confidentiality, but we also have a duty to the tribunal. There are ethics, opinions, and decisions on what weighs more, but just err on the side of the tribunal. The court is like a little bit higher up here, right? We have our client, we have to represent them. But if there's a frivolous claim being given to the court or there's a lie given to the court, I have to remedy that. So I have to take reasonable steps to prevent that. I have to remedy some false claim that I know was submitted to the court. So if there's a submission to the court that's false and my client is telling me another thing, my duty is to the court, right? I have to make sure that the court knows what's going on. And compare that with, I don't have a duty to just, voluntarily give the court information that's detrimental to my client, because why would I still have a duty to represent them. If it's not a false or misleading claim, it's not a frivolous claim to the court, but it's something that hurts my client's position, I don't have a duty to disclose those facts, right? So I still am able to represent my client and I don't have to just, just be like, I show the judge my cards and say, I don't have a case here, right? I can still try and advocate, and I don't have to disclose like disparaging facts about, if my client, slept with someone they weren't supposed to or something. I don't have to just tell them to the court that. But if that is in like a motion and my client says it's wrong, then I have to remedy that. So just, there's kind of like a little give and take here, but just like overall duty to the tribunal is going to be a little bit higher than duty to your client, right? If there's frivolous claims, I have to remedy that. And then very quickly, I have communication with opposing litigants. This is a super easy rule. If someone does not have an attorney, right, they're unrepresented, they're pro se, and that happens. People file things with the court if they don't want an attorney and they totally can act on their own. They don't need an attorney. It's probably not wise, but people do it. So if I have a pro se litigant that does not have an attorney, and I'm an attorney who represents a client that's against this pro se litigant, then I have to confirm that this pro se does know that I'm not their attorney. So if I'm talking to them and the guy's like, yeah, you're great, like you're really representing my interests here, then I'm gonna be like, listen, I'm not your attorney, I'm this client's attorney, and I'm just talking to you to try and resolve it, but my responsibilities and obligations are for my client, and I'm representing them, I'm not representing you. So I have to make sure that the pro se litigant knows that I'm not their attorney, and I have to make reasonable steps to correct any misunderstandings if that pro se thinks that I'm their attorney. And that's like pretty simple, right? So if that litigant has an attorney, I can't talk to that guy. I have to talk through the attorney. If I talk to the client, that other opposing attorney's client without that attorney's consent, that's like totally an ethical violation. So I can't like communicate knowingly with the opposing party about subject matter representation. How does this get tested? I mean, maybe I'm talking to them about the big game next Friday or something that's not related to the representation. I can probably let that slide, but then I can't say like, oh, we're talking about the big game next Friday. But then you're probably going to be, up all night, doing strategy with your attorney. Like, I wonder what you're talking about. Like, I can't talk to a litigant that's represented. I have to talk through their attorney. So just think, there's a pro se guy. I have to make sure that he knows I'm not his attorney. And if there is a litigant that's represented, I cannot talk to him about the subject matter unless his attorney gives me consent. Why would he give me consent? Probably not, but just that's the black letter law, right? Attorney has to give consent that you can talk to my client if you want. I don't know how I am with time. I think it's 8:44. So I don't remember when we go into, but I have some issue spotting if people just want to like, we don't have to go through a whole analysis here, but if people just want to shout out and be like, I think we're going to write about this. So I pulled these from the essays and I obviously cut the rest of it out and I just did the ethics thing. So sometimes if it doesn't make sense, like, just try and fill in the gaps, but let's see. Okay. Yeah, so let's see here. I mean, Hank and Willa, foreclosure lawsuit, they're getting divorced. To reduce legal expenses, they have asked you to represent them both. Love this one. So just shout out, what am I going to write about for this ethic issue? Or type it. Whatever you want.
Conflict of interest?
Yeah, totally. So I am going to probably do ethical considerations, talk about my ethics rule, right? There are things that we have to follow, and if we don't, we're subject to discipline, that whole thing. And then I'm going to talk about the little conflicts of interest heading and say, if, two clients have directly adverse interests, I cannot represent them unless I believe that I can, my independent judgment will not be affected and I get informed consent in writing from both parties. That is going to probably be my big points there, right? I see no contingency fees. I like the issue spotting. I do. But because I know you don't really have like all the facts here, but if I wasn't told about a fee agreement or I wasn't told about Hank gives me 10,000 and Willa gives me 10,000 and says, when you take a cut at the end for 40%, let me know. If I don't see something that's pointing me to a contingency agreement, then I'm probably not going to talk about it. Don't let that shy away from like, I just killed this essay and did a great job and I have 10 minutes left. And maybe there's a little contingency fee, like I'll throw it in there. That's totally fine, but don't pull things out unless you really know, like I know this is conflict of interest. I know that's what I'm going to talk about first. So that is where I'm going to spend the most of my time. And if I have a second, maybe I'll throw in contingency. But I think what I would throw in here too is just like competency, right? And, an attorney has to be competent. An attorney has to diligently represent their clients and has to advocate for their rights. And like, how am I able to ethically represent them both if they are, directly adverse and they're going through a divorce? I still have the duty of confidentiality, right? So during this divorce proceeding, I'm probably learning information from Hank and I'm learning information from Willa. How am I going to keep it confidential? So I think those kind of pop out a little bit more. But that's up to you what you spot. But I definitely think like the catch-all ones, like The confidentiality, the professionalism ones, I would like talk about that like as a default if I have time. Obviously after I like catch the big issue spots, but love the issue spotting. This one's very quick. Move my little chat box. So balance of seller's attorney trust account was over $750,000 at the time. Seller's attorney deposited the check into seller's attorney trust account, which included funds from other clients as well as the seller's attorney's own business venture. What is the attorney doing here when they're taking money and putting it into an account with their own business venture money? Yes. Yes. So what am I going to talk about here? My ethical prompt, trust accounts. I'm going to say attorney has a duty to keep clients' funds separate from their own funds and not commingle assets and keep them in a separate trust account. And, attorney did not do this, so they can be subject to ethical violations. And the ethical thing would be to have two accounts, one for client funds only and one for personal. And, maybe because I did cut this off and that's why I put the July 2012, so you can go read it on your own. But if they did talk about fees, then I would talk about reasonableness, right? I would talk about what's a reasonable fee? Is it comparable with work in the area or the type of case involved or the complexity, right? I'm talking about fees must be reasonable and not excessive. So don't just black letter law, that's what you're zooming for, right? Like bing, bing, bing. But yes, Alexa, commingling assets. Let's do this one. This one is kind of like a funny one, but your client says that I'll be willing to forget what this guy told me, right? The client says, hey, I actually know that the guy that we're suing didn't really, say this truthfully, but I'll be willing to forget that, right? If the client says this to me, like, what am I thinking of here? I have this false thing going on, right? My client is telling me something false. What could happen here? Yes, Alexa's killing it. Duty of truthfulness, right? So maybe I take this information and I can't say it to a third party, right? I have a duty of truthfulness to third parties. But what also happens with the truthfulness thing, right? So if I get information from my client that's not truthful and then they want me to advocate, yes, Natalie, duty of candor to the tribunal. So what happens if my client tells me things and then I have to file a claim? I know it's false and I'm giving a frivolous claim to the tribunal. That is a big no-no. So I'm going to talk about my ethics blurb. I'm going to talk about duty to the tribunal. Yes, Pablo, I probably would do that as well. And yes, I could talk about truthfulness also, because we are talking about a truthfulness thing here. So that's a great mini one to think about, right? So there is big dollar signs for things that we're seeing when we're issue spotting. I know it's this. So for this, I would say duty, candor to the tribunal. That's my dollar sign. And then there's a little mini dollar sign that I can be yep, truthfulness and maybe competency, right? So don't forget, there's a big one that you're going to get points and there's little mini ones that you can throw in and see what sticks, but definitely you got to issue spot the big ones. So what's this one? Oh, we have a referral fee. So the lawyer proposes your firm will solely litigate Paula's case, and pay a lawyer a referral fee equal to 10% of any fee you earn in the case. What's wrong with a referral fee where one firm is solely litigating something? Yeah. So referral fees generally are not allowed. We know that. However, referral fees can be in writing. They have to allocate percentages of work done, or they assume joint liability for wrongdoing. So that's my black letter law. And then here I have a firm that's solely litigating and getting a referral fee. So they're not allocating work. They're not doing percentage wise in this referral agreement. So that's unethical. And then I can always throw in, attorneys can talk to another attorney to become competent at representation and ask for advice because this lawyer doesn't practice personal injury, but maybe I have a friend who does. Do I call him and say, hey, let me take this case and give me $10? I'm going to call him and say, listen, can you help me with this personal injury? Just give me some, maybe a CLE that I can watch. Attorneys can talk to one another, right? But I just can't start doing work on a referral fee agreement. and do it all and then give you a cut. Like that's just unethical. But yes, and then I think this is the last one. So conflict check, that kind of just told us, right? Conflict check reveals that a lawyer at your firm represented Chipco, which is a former client from 3 years ago. And we represented them in an employee slip and fall. So we represented the employer. The firm has not represented this company since the case settled 3 years ago. And I did cut it out, but I know that the other side, right, the employee is now coming to me. So where am I going here? If I see I had a, yes, former, Natalie is killing it. So former client rule, I had a client that I represented 3 years ago, and now I have a client coming in that's substantially related to that and materially adverse. And perhaps, you know, just like the other question was asked, perhaps I learned information that's disparaging, and sometimes they may not tell you, but you can just like say it. Like in case they learned information that's disparaging, then they would have to turn on representation. So that is great. And I have heading and subheading for ethical issues because like I said, the ethical considerations would be like a really big main one with that block that I said in the first slide. And then the subheadings would be like confidentiality, duty of candor, conflicts of interest, right? So like put it like spoon feed it to them, right? Like don't treat them as like stupid idiots, but just be like, listen, I'm going to make sure that you know what I'm talking about, and I'm going to lay it out for you like this, and I'm going to put headings, and I'm going to put black letter law, and then I'm going to put analysis, and then I'm going to conclude, and then I'm going to move on, and you're going to give me a passing grade. So, oh my God, I have one more, sorry. So yeah, the first one is, you know, I'm kind of just gonna like give it to you a little bit here, but you have an attorney and a client that are talking about like, let's say we win this, you know, lotto and we go into this like joint venture together, right? So we're going to swap professional services, engage in this business thing. What happens when we engage with our clients in a business venture, right? So yes, duty of confidentiality is a good one to think about. But I will say that here is like the business venture rule, right? So an attorney can't enter into a business relationship for an exchange of fees with a client unless the client is, you know, and then we have our 4 elements that I hopefully can recall, where the client is made aware about what's going on in a way they can understand, where the client, it's a fair and reasonable transaction with the client, and the client gives informed consent. And there's a 4th thing. Should we go back and look? See, this is what happens when you... Yes. And independent counsel, that's what we missed. We have to also make sure that they have independent counsel. So that's for the first one, right? And then for the second one, we have, if you think you can sue me again, I know how to drag out a lawsuit for years and make you miserable. If an attorney says that, we know what we're putting here, right? We definitely know what we're putting here. I would put all of it. Yeah. Yeah, Alexa. I would say, you know, attorney has to be professional. Don't forget, you can also just say attorneys are living up to the standard of professionality. Like we have to make sure that we're treating people with respect. Like just say things like that as well. If I see this, that's how I know I have to talk about just being a kind person, right? That's kind of a logical thing. But yeah, I can, you know, frivolous claims, I'm dragging out a lawsuit for no reason. So I'm not being, you know, I don't have candor to the tribunal here. I'm not being truthful. I'm not engaging in a professional way. You know, maybe I'm not being loyal to my client because I'm not doing things in their best interest. I'm not being a zealous advocate, right? So there are a lot of things we can throw out there. But that's the thing with ethics. It's kind of like I see things and I can talk about them and I'm gonna get points. So these are little links. First one is my email. If you have a question, you can ask. But then the case text is like how I pulled the statute. So you can just type in like case text Florida ethics rules and then like former client rules. And it'll have the statute right there. You can take a look. So I hope this was helpful. And hey, can you just press stop? So I can definitely press stop. And if there are questions, they can answer them. But thank you very much for everyone who came today. I'm happy to talk to you. I did just stop it. So if anyone has questions they want to ask me off camera, I'll be happy to answer them. Everyone says thank you and you're welcome. I'm happy. I know ethics is like kind of boring, but when I learned ethics, I was kind of like, oh my God, like that's my last substantive lecture. Like, ooh, like I'm getting so close. But it's really kind of like, yes, we're at the home stretch here, but don't be like, oh my God, I have this amount of days left. Every day we do the same thing. We wake up, we have things to do from this time to this time. We stop for lunch and then we, cut it at a certain hour and then we maybe watch trashy reality TV and then go to bed. That's what I did. That's how I relaxed at the end of my night. But we have our little structure, we have our schedule, and we're going to do that we're just going to grind it out every single day. That's what we're doing until test day. Every day is just another day. Don't be like, oh my God, like the calendar is going and like, where is July going? Like, people get into their minds, but don't forget, half of the battle is your mental clarity on test day, right? Half of the battle is just knowing how to just be in the right mindset and be like, I've looked at this material and I'm gonna recall it on test day. So let me just like chill for a sec and recall it because I know it's in there. I've read it a billion times. I've done a billion practice questions. I know it's in there. So let me just chill and pull it out. If anyone wants to send me an email about like tips to do before test day, like I'm definitely happy to answer them. But for those taking the MBE, what I really like to tell like my own tutorees is if you have Adaptabar or something that is like mock questions, I would definitely do like just 5 mock questions like the morning of your MBE and just knock it out. And you don't even have to care about what you get on them, but I think just telling your brain like I'm going to look at questions now. You put yourself in the frame where I've been doing this for 3 months every single day, where today is just another day. I'm going to wake up and I'm going to look at these questions and be like, I don't even care what I get on them. As long as I'm reading an MBE question, then I'm not sitting on test day reading an MBE question for the first time today. I'm not doing that. I already looked at them in the morning when I was eating my bagel. You know what I mean? Like, just think of it as like just another day. And yeah, there's gonna be people there and whatever, but be like, oh, like I'm not talking to anyone. I have little earplugs. Like I definitely recommend. I put my earplugs in when I was like on the line to get in. Like I'm not talking to anyone here. Just like leave me alone. Like just Zen moment, okay? I don't want to take up any more of your time. Please go to bed. So thank you so much for coming. Good luck to everyone. I really, really believe in all of you. And, like Gabby said in the beginning, just take every day as like, I get to study for the bar exam. I get to take, not everyone takes the bar exam in their life. And that's like a pretty crazy thing to do and say to people like, I've taken a bar exam. Like, have you? So definitely just say like, I get to do it. I get to wake up every day, have my little schedule, eat my little snack, and then go to bed. And it's a nice little life. And then when you start practicing, you're like, oh my God, now I have to be an attorney. And you're like, but it's all worth it at the end. So yes. Good night, everybody. I hope everyone has a great time the rest of the week and the rest of the session. And please, give me a phone call or email if you need anything, and I'm here to help. Okay. Good night, everyone. Bye-bye.